For those of you who have been fighting the system, naming child support amongst other cases are also known as contracts. We at E. Mitchell & Associates has come to the realization via our legal experience that one of the best ways to defend your case, you must bring forth your suit in equity via USC 42, 1983, inside an Article 3 court within a federal jurisdiction. By sending idle threats, forms, and citing case laws to these entities has no bearing on them. You must bring them forth. It also applies even so with mortgages, because it too in nature is contract. You see, the burden of proof is on you as the complainant, aka plaintiff. If you have time, I will briefly explain what you will face in this process. You see, we at E. Mitchell & Associates does not win or lose cases. We only prepare your case. Since you are pro se, it's up to you to win or lose your case in your preparation, because at some point you will sit in conference with the defense attorneys, and your preparation will make all the difference in the world. Studying. So, the information that's being brought to you is for legal educational purposes only and must not be misconstrued with legal advice. Now, let's get started. If you bring forth your complaint in state court amongst state actors and bar association members, their defense will always be that they have sovereign immunity against any and all suits against them and their agencies. They'll wholeheartedly stand on the renowned case law of Rucker-Feldman, a U.S. Supreme Court case coupled with the Rucker-Feldman Doctrine. So let's see how we can diffuse this course of action. Here are two laws I would like to present. Look at 15 U.S.C. 1122. It clearly states no immunity to state actors. Now, let's concentrate on A and B for a moment. Once you've paused to read this video, now let's review C. C clearly states your remedies. Now, if you don't know how to present your case to the Chancellor of the Court, he would dismiss your case for failure to state a claim upon which relief can be granted, also known as Federal Rules of Civil Procedure 12b-6. As a pro se litigant, you must show plausibility and orchestrate pristine paperwork. There are so many weapons to use against these corporations to dismantle them, but you must conduct your paperwork in a manner parallel of a chess match. Now, let's take a look at 42 U.S.C. 122.02, which states clearly that a state shall not be immune under the 11th Amendment of the Constitution of the United States from an action in ... Child support cases are notorious for building their defense on this particular subject. Okay, it looks as though we're getting contradicting messages here. Title 42 will apply to civil rights, correct? But by the same token, we know that state actors claim sovereign immunity, and the courts will act accordingly. So how do we resolve this conflict? Point A, do you have to quote them in federal court? I would suggest that would be your best bet, because if you try to take these people on in state court, state judges pick and chooses what federal laws and state laws, statutes and codes by which they're going to honor. In federal court, there's no picking and choosing. A federal court has to follow federal law. It is state versus federal. I don't play well with others, so I go to federal court. You see, when you bring a claim against these agencies and corporations such as child support, mortgages, etc. for fraud, you must present a valid case to solidify your claim for fraud. Now, state sovereign immunity and tort liability is somewhat different. Let's talk about it. Now, sovereign or governmental immunity concerns themselves with the various legal doctrines or statutes that provide federal, state, or local government immunity from tort-based claims, as well as exceptions to or waivers to that immunity. Generally, a state government is immune from tort suits by individuals under the doctrine of sovereign immunity. The terms sovereign immunity and governmental immunity are frequently conflated, but they are entirely different legal concepts. Sovereign immunity protects the state and its divisions, including agencies, boards, hospitals, and universities. Governmental immunity technically only protects political subdivisions of the state, including cities, counties, towns, villages, and school districts. Throughout the country, case laws has continually conflated these two terms. For the purposes of this content, I will refer both terms interchangeably. Local governments, municipalities, and political subdivisions of the state are immune from tort suits by virtue of governmental immunity, because the state grants them immunity, usually in its constitution. The charge deals with state governmental immunity and liability. It should be noted that lawsuits against states, their officers, and employees are frequently asserted under federal law, e.g. 42 U.S.C. Section 1983, or similar statutes. What I'm stating deals only with a separate body of law, governing state law towards claims against state governments. It doesn't cover federal claims under the Federal Tort Claims Act, FTC, 28 U.S.C. Section 2674, which is the subject of another claim, negligence against municipal, county, or local governments, which is also the subject of another chart. State laws may provide for discretionary functions with an exception to state liability. A discretionary function exception retains state immunity for a central governmental function that requires the exercise of discretion or judgment, such as planning or policy-level decision. These discretionary functions are distinguished from ministerial or operational functions that involve only the execution of policies or set tasks. Now, the states may also employ a misrepresentation exception clause to states' liability. A misrepresentation exception only means immunity still applies in certain cases of governmental failure to communicate correct information to you. With all that said, again, when presenting your claim to the courts for misconduct by these entities, please navigate your paperwork to the fullest. And thank you for taking the time to listen. If we can be of any assistance to you in your legal matters, please contact us to discuss your particular situation. Thanks again.